Morning.
SJC-10782, Commonwealth versus Gray.
Let's proceed. Yes.
Good morning, Your Honors. Attorney David Mirsky for Terry Gray. The first issue I'd like to discuss is the manner in which the trial judge violated the Sixth Amendment and the 14th Amendment under Sullivan versus Louisiana based on an instruction that the prosecutor sought in order to tip the scales of justice against the defendant and in a way that is not allowed under the Constitution by inserting the judge in multiple ways, actually, putting the judge into the determination of what evidence should be considered as far as the determination of reasonable doubt. Also suggesting that the job of the jury was to convict and to only consider evidence, or to be able to consider evidence that the defendant committed the crimes, and that fairness required them to look at that evidence asserted by the Commonwealth as showing guilt and not to consider the absence of other evidence which may have been suggested by the body of evidence at the trial as it was, that there was a lack of corroboration for the...
Mr. Mirsky, if I understand you, your complaint is that the trial judge asked the jurors if they could find the defendant guilty without DNA or fingerprint evidence.
Yes, Your Honor, but also that the trial judge directed the jury that it was their job to consider the evidence asserted by the Commonwealth to show that the defendant was linked to the crime scene and to show that the defendant committed the crimes, and to not pay attention to the other evidence that might have been missing. And as the Commonwealth itself introduced evidence that there were tests done for fingerprints, there was the possibility of DNA evidence being collected that wasn't particularly important. I would say the defendant's glasses were not.
Is it your position that in order to convict someone, there must be DNA evidence and there must be fingerprint evidence?
No, Your Honor. The point is, and the point of Sullivan versus Louisiana, and why this is really an egregious thing that's happened in this case, is that the job is for the jury to determine reasonable doubt. And that you had basically the main evidence coming through witnesses who had questions raised as to their credibility, and yet, and normally a jury might look and the prosecutor might seek to present evidence that would corroborate that, and the judge, the instruction that was given indicated to the jurors that their job is not to consider what wasn't there. So the fact that the defendant's glasses did not come up with evidence of blood spatter on the defendant's glasses is not to be considered. That's what this instruction, these questions and instructions tell.
Did the judge instruct the jury that they had to find that the Commonwealth had proven each and every element of the charges against the defendant beyond a reasonable doubt?
The judge instructed that, but what the judge did was change the definition of what a fair juror should do in making that determination, and remove, and when the jury looks at all the evidence, even when they're making credibility determinations, they're going to look at all the evidence that came in at trial, and every little, we don't know, and it's not our job, and it's not the appellate court's job either, to decide whether reasonable doubt existed. It's the jury's decision, and this judge took that away from the jury by telling them they should focus on excuse me, Your Honor.
Sorry, I want to make sure that we're talking which instructions we're talking about. You may raise the Bowdoin defense.
There is a Bowdoin defense, but Bowdoin, the case, is not sufficient here.
I understand, but I mean, when you say instructions, you mean initially in the word, you don't mean ultimately. The ultimate instructions.
Right,
you
I'm
have no
talking
quarrel
about,
with.
Your Honor, I'm talking about the question that the DNA and fingerprint question.
That with respect to 7 jurors that suggested that they only could focus on the Commonwealth's evidence, and that was what they were to do, and ignore the fact that there wasn't
yes,
anything.
yes.
And you don't think
I'm
that
not
was
talking about later, although there is something that happened later, which is that the prosecutor, during his closing,
Right.
was permitted to, in essence, give the instruction to the jurors, an over-objection, that their job is to not look at the fact that there was no corroborating evidence, and actually to credit the witnesses of the Commonwealth who testified, the police witnesses. Amy Kratz was one of them, Jason Gall, I believe, Tyrone Camper, that you shouldn't pay attention to the lack of fingerprint evidence, and also I'd like to point out there was a cup.
Just want to clarify, you're not arguing that they therefore had biased jurors who only would look at DNA. You're suggesting there was something wrong in the instructions, so they might have come into the trial thinking that's what they had to do. So my question about Bowdoin and the judge's ultimate
Both,
instructions.
Your Honor.
And the ultimate instructions, was it clear from you have no quarrel with the ultimate instructions to the jury at the end that they were to pay attention to everything, including your defense?
What I'm saying, Your Honor, is that each juror, first of all, was selected to be able to, as Perez says you're not allowed to do, and also Perez says you're not allowed to, it calls it abusive discretion to suggest that a lack of scientific evidence could not be considered in determining whether a reasonable doubt existed. However, it's more than an abuse of discretion. It's a violation of the Sixth Amendment because the jury has to make those determinations. When the judge enters into the evidence and tells the jurors, you don't consider what might be missing. And this isn't a matter of an affirmative defense. We're talking about evidence that was in the trial, and it was admitted, it was admissible, and the judge is telling the jurors and selecting them that way. And there was one particular juror, juror 102, who was uncomfortable with that, and this juror was excused for that reason. Now, the way that the judge is
Was that wrong?
It's wrong, Your Honor, that
No, I mean, if a juror says, no, I could not convict without DNA evidence or whatever, fingerprint evidence. Is it wrong?
they're not asked that. That's not what they're being asked. They're being interfered
But my
with.
question is it wrong for a juror to be excused because they cannot convict without DNA evidence?
I think it would be wrong for it to be shown by a question that particularly did not address the evidence at trial or talk about this case, the particular case, whether there was a bias against, for instance, police officers, or whether there was a bias because of some external reason.
How could a judge find out if a jury or if a juror would not be fair and impartial because that juror insisted upon having DNA or fingerprint evidence?
Your Honor, first of all, there are cases where a question is asked and it's tailored in a narrow way and it doesn't step into the juror's determinations of reasonable doubt as was done here. However, that's not the job here to decide here, Your Honor. The job is whether this jury can do their job and protect the defendant's right to.
But it's okay for a judge to ask a proper question that would determine if a juror.
A proper question that's tailored to not do what was done here.
Okay, so the question here is what would have been, the question I'm asking you is, what would a proper question have been?
I don't, Your Honor, you know what, I can come up with, dream up things, but I don't think that's.
Give me one.
Perez has some.
I think there could be a question where directly, would you, if there was no, well, first of all, it can't be specific evidence that is going to be in this trial. It can't be entering into the evidence. It could be like, for instance, are you able to follow my instructions? Are you able to make your determination based on what is presented in court, but not getting into what these particular jurors are going to decide?
In Paris, we said that the Commonwealth is never, this question, never able to prove a case beyond a reasonable doubt unless it presents scientific evidence to corroborate witness testimony. We thought that was okay. And
I'm not, you know what, Your Honor, I'm not going to pass on what's okay because I'm telling you this is not okay. That's what I'm here to tell you.
Can I understand this a little better? So the judge asked each of the jurors a question. Did he ask a general question, or was this done an individual voir dire?
He asked individually each juror this main question, which I've called the DNA and fingerprint question, which has some slight variations, but I've quoted in my reply brief and in my brief.
All right. So, well, maybe
And then
I'm at the wrong quote, but essentially it says, would the absence of DNA or fingerprint evidence prevent you from fairly evaluating the evidence in this case?
That's the last part of the question, Your Honor. That's not the whole question. The question is, it is expected that the Commonwealth will not introduce DNA or fingerprint evidence to link the defendant to the crime scenes. The Commonwealth will allege that it possesses other evidence to demonstrate the defendant committed the crimes. Would the absence of DNA or fingerprint evidence prevent you from fairly evaluating the evidence in this case?
What's wrong with that
And then,
question?
because, Your Honor, first of all, under Charles versus State, that's indicating to the jurors that their job is the job that they're there for is to make sure they can be able to convict, and that's not a suggestion that should be in the question. But more importantly, the 14th Amendment requires proof beyond a reasonable doubt of every fact necessary to convict. The jury makes the reasonable doubt determination. They look at all the evidence at trial. You can't tell, the judge cannot step in and tell the jury, okay, well, there may not have been some fingerprint evidence here, or there may not have been, we didn't bother to test the cup that was found in Mr. Wilson's apartment for DNA, but you can't consider that.
Is that what the judge said in his closing argument?
That's what this is saying, Your Honor.
well, that actually, I think maybe in some of these cases that might come up in this further explanation when jurors seem confused or were disinclined to accept the premise. He'd say, would you be able to focus solely on the evidence the Commonwealth presents and decide whether or not they've met the burden?
Yes.
So I thought your issue was not in every case, but you picked out these, and there were several, where he's then focusing is just look at the evidence and on that basis decide whether they've met the burden. And what I thought your argument was that by focusing on whether they've met the burden on the presentation, they couldn't also consider whether there was a
Yes,
reasonable
that's
doubt
it, Your
by the
Honor.
absence of evidence.
Yes, Your Honor. And not, and we're talking about evidence here that the prosecutor was concerned about, that did not, because you had witnesses who one did not come forward right away, one changed his story, there were questions of credibility, and the DNA, and well, put aside DNA, fingerprinting evidence was sought and not found. There was DNA evidence possible.
All of this was presented to the jury? And what did what did defense counsel argue in closing?
That you should consider the fact that there's nothing here but these two witnesses who are not believable.
Okay. Seems like a fair argument.
And the judges had already gone through the jury pool and selected out people who would consider in determining reasonable doubt whether something was missing here from the body of what was in the case. The judge essentially came in and stepped on one side of the scales of justice with his hand and his instructions. And particularly these instructions that I've highlighted in footnote 4 of my reply brief, that were done when jurors would not really accept this, because we're not talking here about a problem that existed, because Perez notes that there is no problem out there empirically from evidence that that there's a CSI problem with jurors. Okay, so what happened here is that the judge came in and the jurors had a problem with it, and juror number 102 had a problem with it. And the judge even couched the whole definition of what's fair based on your ability to convict and based on your ability to put aside what might be missing and look only at the Commonwealth's evidence. And that's exactly what is wrong here. And that is what shifts the burden of doubt, the burden of proof, and what does not allow the jury to do its job. And I would say, even though this was prejudicial error, but prejudicial error doesn't apply here, because this is not the job of the appellate court to sit here and decide whether there was reasonable doubt. That's the jury's job. The jury didn't get that opportunity. And that's what Sullivan versus Louisiana, that's what Sullivan versus Louisiana says. And that's what's so important about this case. It's the jury that has to decide. The judge, we don't have a CSI problem to begin with, but we have instructions and we have manners of selecting out biased jurors, and we have many ways of asking the questions without entering into the minds of each juror and telling them, don't pay attention to this part of the case. And the prosecutor, even in his closing, emphasized that, the instruction. You're not supposed to look at that. You have to listen to my witnesses that told you don't pay attention to the lack of fingerprint evidence. That's not appropriate, Your Honor, Your Honors. And that's a serious problem here. It's something that I don't see. When I read countless transcripts, never see this type of thing. It's very unusual, and it's an attempt to, I believe, it was a question that was sought by the Commonwealth, and it's attempted to cover up an absence of evidence and not allow the jury to just do its job, which is to sit there with an open mind and look at everything and listen to basic blind decision-blind instructions that tell you how to look at the evidence and what the law is, and that's not what was done here. I'd like to discuss the other issues unless there are any more questions on this. On the severance issue.
Well, we have 2 murders and an assault, 3 separate incidents.
There's 3 alleged incidents, Your Honor.
And they were joined for trial.
Excuse me?
They were joined for trial.
They were joined, yes. Okay. And there are 2 issues: whether they were properly joined and whether there was so much prejudice, unfair prejudice, that they should have been, even if properly joined, should have been severed. And I would just point out on this issue that this is not evident. There's not sufficient evidence that this is a single scheme or plan. These are very separate events. One of them, the first one, alleges that there was a cousin present with the defendant talking to an uncle over insurance money owed principally to this cousin, and it was done with witnesses in present.
Same ammunition, though, wasn't it?
Ammunition is not an issue with the charge of the assault and battery charge, Your Honor. Yeah.
Murder cases?
No, I'm talking about the first. What I'm talking about, Your Honor, and the focus of my argument on the severance issue is that the assault and battery charge is an outlier and should not have been joined, and that it's first of all not shown to be part of a single plan or scheme, and second of all that there's such strong unfair propensity evidence out of that alleged event, that it was used to fill gaps. Actually, the very joinder itself was like evidence telling the jury, well, these were related, but the evidence didn't show that.
Well, what was the time sequence here of the assaults? What came first, what came second, what came third, and how far apart were they?
I have that. The alleged assault and battery on MacArthur Powell was alleged to have occurred on June 16th, 2005. the alleged murder, the death of, the allegation is that Charlie Wilson was murdered on July 9th, and the allegation is that James Gray was murdered on July 12th. This is all 2005. The Gray charge, the James Gray charge, the jury did not come to a decision, and that has been null-prossed. Basically, what you have here is a very, very, very different alleged modus operandi, very, very different events, and you have no corroboration or identification evidence or very weak evidence in that regard regarding.
Well, MacArthur, the defendant held a gun to his head, right?
The allegation is by MacArthur Powell as an alleged eyewitness that he saw that the defendant did that to him, and that becomes identification evidence that the joinder will then impute to the jury that it should be implied that the defendant is a bad guy and has the propensity to do that, and therefore you should consider that as evidence of guilt in the murder.
MacArthur Powell was a family member?
Yes, Your Honor.
Okay, and the other two were also related?
Well, Wilson is not a family member by blood, but is like a family member.
Right,
Okay.
okay.
Mr. Mirsky, your time is up.
Thank you, Your Honor.
Good morning. May it please the Court, Allison Callahan for the Commonwealth. I'm joined at council table today by the trial prosecutor, Masai King. Commonwealth asks that the Court affirm these convictions. Turning first to the issue of severance, these crimes were properly joined. This was an attempt by the defendant to go through what he himself called his list in his interaction with Early Powell at the hospital in the time between the assault and battery with a dangerous weapon and the two murders. He actually visited Early Powell in the hospital. And after speaking with him and confirming with the defendant's mother that he had never been molested by the defendant, that the defendant had never been molested by Early Powell, the defendant's own words were, "You're clear. You're off the list." The time frame we're dealing with is approximately 1 month. In early June of 2005, the defendant started making inquiries of family members about the possibility that he had been molested by a number of family members. To put it into context, in El Powell, the defendant's mother is one of 15 children, so we have a number of different family members by the same name. The defendant also, in the course of these inquiries, raised the issue of his of his father having been beat up by a number of these men 30 years prior. So we have motive to approach these individuals, motive to carry out some sort of act against them, and he starts making inquiry. The first inquiry we're aware of is on June 15th, 2005, in the assault and battery with a dangerous weapon on MacArthur Powell. My brother argues that this should be separate, in large part because of this other motive of money, because he was with Reggie Santos. However, I suggest this was just another reason for him to be there. It was clear that MacArthur Powell was somebody who he felt had wronged him in some way, and he actually made mention of that during the incident. He brought up the beating of his father, and in response, MacArthur Powell, responded, "Yes, they did beat me." The way that incident took place was the defendant leaned down on the bed as if praying. He then asked MacArthur Powell if MacArthur Powell had seen what he'd done. He told him to do the same thing. He put a gun to his head, and he asked him how he wanted it. We then, as I said, see this incident with Early Powell in a hospital, where he approaches him about whether Early Powell ever molested him.
So the MacArthur incident happened before the visit to Early?
It did, Your Honor. The MacArthur Powell incident happened on June 15th of 2005. The Commonwealth alleges that the two murders occurred, Charlie Wilson's murder occurred on June 9th of 2005, And we believe that James Gray's murder occurred on July 12th of 2005.
So it was the MacArthur incident, then the visit to Early Powell, then the murder of
Charlie Wilson
Charlie
on
Wilson.
July 9th.
and then the murder of
Mr. Gray.
Mr. Gray.
Correct. So while the incidents do have some differences, I'd ask the court to look at the similarities between them. We have the shared motive. We have the use of the gun in each of these. We have the defendant signing his own name in the James Gray homicide, and the same gun is used in the James Gray and the Charlie Wilson homicide.
Was the gun ever located?
The gun was not ever located.
Then how do you know it was the same gun? Just because you have the same ammunition?
The same
the bullets.
ammunition, that's correct.
I mean, were the bullets analyzed?
They
or
were,
the-
and a ballistician testified at trial to that effect.
You don't have any evidence as to the gun that was used in the MacArthur?
We
incident?
don't. We don't. And MacArthur Powell was frank about the fact that he had not been able to see the gun because that gun was placed behind his head, so he was unable to see it. So for all those reasons, the joinder was proper here because of the connection between the crimes. That connection indicated that this was a single course of criminal conduct, and the defendant's goal in this conduct was to ascertain who had abused him and who had beat his father. Whether or not, whatever reason there was for that, that was his reason in doing it. Turning the court's attention to the next issue, the voir dire of the jurors.
Isn't the danger with the kind of question that was asked that jurors would be selected who would be inclined to discount the absence of forensic evidence, which is a factor that can be taken into account by jurors in ascertaining whether or not there is reasonable doubt?
The important thing to focus on with this question is the manner in which it was asked.
But the question evolved. It's not exactly the same question put to all of the jurors.
It did evolve. However, it's clear if you read the entire conversation that the judge is asking each juror if they can evaluate the evidence, if they can, even if this evidence is not there, if they can look at what's presented to them, all of the evidence. He's not doing something akin to Bowden where the judge says, you may not consider the absence of this evidence.
Well, let me ask you a question, because it's not clear to me what in the final instructions the judge told the jurors about this whole question and what they can take into account or not take into account.
There was no follow-up instruction in the
Was this all objected to?
it was.
It was objected to where there was no instruction requested in
No.
any way to deal with
There was not.
the whole matter of the absence of forensic evidence?
That's
or-
correct, Your Honor.
There was evidence there was evidence that no DNA testing had been done, wasn't there?
That's correct.
And there was evidence that no fingerprint of the defendant had been obtained?
That's correct.
And the defense counsel argued those points to the jury.
He certainly did. If I could turn the court's attention to the closing arguments in volume 7, pages 44 and 45, we hear the defendant's argument as to this issue. And the defendant argues about the volume of evidence involved. He says, look, it's quite clear that these two crime scenes, and you better ask yourself, it's quite apparent that there's two different killers here. James Gray was severely tortured. Teeth were yanked out, hands and legs bound, whipped, blunt trauma to the head, crushed with a dumbbell, shot. No DNA. She testified there was sperm in his penis and maybe in his anus. No DNA. How do you rectify this, ladies and gentlemen? We need DNA here. There's got to be DNA. If someone's getting an awful beating like that, tortured, isn't there sweat coming off that person that's torturing? Isn't there DNA left at the scene? They decided not to do that. That is inexplicable. That is wrong. That is reasonable doubt. There is no justification. And then the defendant turns his attention to the lack of fingerprint evidence. He says, I questioned the person that did the prints. There were things sent to the print lab. Glass table for Mr. Gray's place. Prints were recovered. Mr. Gray was excluded. What did you do with those prints? Nothing was done with the prints that they found. Could they have been the killer's prints? We don't know. DNA. Charlie Wilson with the plastic cup. Did you do the DNA on that? No. Why? Well, I was told that the suspect was part of a family. A part of the family? And then the defendant talks about the DNA again.
Well, there's no question that the defendant raised it in the closing argument, but the question that I guess that I'm concerned about is what would the jury have been able to do by way of what law they could bring to that? I mean, how to evaluate what they just heard? I mean, if they had been under the impression, as the defendant is suggesting, that the absence of such evidence was inconsequential in ascertaining reasonable doubt, then that could be a problem.
Certainly.
And so I'm just trying to hear or learn what there might have been by way of legal instructions that would have helped them to evaluate that argument.
Then I would look to the rest of the judge's instruction. As there wasn't a specific instruction, the rest of the judge's instruction was proper as to reasonable doubt, as to the Commonwealth's burden of proof, and as to the elements of each crime. And taking...
But did the judge suggest, the judge did not give them a Bowden instruction, did he?
He did not.
Was one requested, by the way?
I don't believe it was. And again, I would just suggest that the follow-up here that we're talking about is the judge has already asked the juror, can you evaluate all the evidence? Can you look at it? So I don't think this follow-up question tells the jurors that they can't consider the absence of...
I don't know that I can agree with that, because the focus is on the presence of, in the sense of, you asking them, would they be able to decide it and look only at what was presented rather than what was absent. So the focus is on, focus on what was given to you. And that's why maybe in these circumstances, of course we don't require Bowden, but in these circumstances, how else are they going to decide that it should be considered, particularly if they come to this with the thought that, we only look to see what was produced, not what wasn't.
Certainly. I would suggest to the court that in this case, looking at the entire instruction, and I understand I'm arguing something that's different than I believe that Your Honor sees, I don't think that that's what's being asked of the juror. Because of the entire instruction and then taking the
Can you point to something in those instructions? I haven't looked at them.
in the final
that this-
charge?
Yes, that would have overcome a potential bias that they came
Not
into it?
not specifically, Your Honor. Again, I would reiterate, the rest of the charge was proper. The standards on the Commonwealth's burden of proof, reasonable doubt, and all the elements of each of the charges were properly given. And I would also note that in connection, it was actually given in connection with the severance, the issue of severance. The jurors were re-instructed on the elements of the crimes and the Commonwealth's burden of proof during the course of the testimony. That was done at the defendant's request, and it was done to ensure that the jurors were looking at all the elements of the crimes. I would just, and I won't read them for Your Honors, but I would just ask the courts to look at the instructions in Volume 5 at pages 86 and 87, and in Volume 6 at page 98. There are no further questions on that issue.
Well, let me ask you this. In Commonwealth versus Perez, we were
Yes, Your
faced
Honor.
with a similar set of questions asked of jurors before they were impaneled, and we concluded that although this was fraught with danger, that in that case it was okay. And we pointed out that it was okay because the questions did not suggest to potential jurors that a lack of scientific evidence could not be considered
Correct.
in determining whether a reasonable doubt existed as to the defendant's guilt. Do the questions asked here suggest what we said the questions could not suggest? In other words, do the questions asked of these jurors suggest that the jurors could not consider a lack of scientific evidence in determining whether a reasonable doubt existed?
I believe that the questions asked here are in line with the questions asked in Perez, which were found to be proper.
Okay.
Turning the court's attention to the last issue, that of ammunition that was seized, suggests that the search warrant was properly denied. The officers were properly present within this residence. Alicia Gray had let the officers into the residence. They informed her that they would be freezing the apartment after a conversation with her where they ascertained that the defendant, in fact, lived there, that he had stayed there the night before. They informed her that they would like to get a search warrant for the residence, and they informed her that they would be freezing the residence. Within that short period when the detectives were first there, and one detective testified that it was less than 5 minutes, 2 other officers from the Youth Violence Strike Force arrived. And these were the officers who were going to be maintaining the location frozen while the detectives obtained a search warrant affidavit. Those detectives were essentially waiting for their marching orders, standing in the kitchen. And as they stood in the kitchen, off the kitchen is a small laundry area. Up on the wall is an electrical box, and on top of that, they observed a box that said PMC. It was a box that the officer recognized to be an ammunition box. I believe it actually said ammunition on the back, although my memory is not positive as to that. And they informed the detectives of that. They in no way touched it. They testified that they didn't have to move it to observe it. So based on those observations, again, they told the detectives what they saw. That information was included in the search warrant. Suggests that this was not in any way a search. The observations were in plain view, and that information was properly within the search warrant. As such, the search warrant stands. The ammunition was subsequently properly admitted at trial.
What was the relevance of it? Was it to the possession of ammunition charge?
It went to the defendant's ability to access the instrumentality of the crime.
Except that we know that there was a different kind of ammunition in the
Correct.
guns that were used in the murders.
Correct. That was
So I'm not understanding what his ability to access it would have to do with the murders.
In other words, his ability to access any ammunition would make it more likely that he could have gotten some type of ammunition to commit these crimes. If there are no further questions, I'd rest on my brief. Thank you.
Thank you, counsel.